Lots of people get concerned when they start looking into estate plans because the whole thing is a big, complicated beast with many moving parts. So in this video, I'm going to break down what each part of an estate plan is and what it does for you. An estate plan consists of three parts: a will, a trust, and durable powers of attorney. You've no doubt heard of a will before. It's a legal document stating anything that you want done after you die. Wills are often wrongly seen as the documents that determine who gets your stuff, but that's not actually the case. A will is meant to state any actions you want taken after you die. Symbolic gestures like whether or not you want to be cremated or have your ashes scattered at a specific place, things like that. You can discuss specific valuables that you want to give to a friend or family member after your death, but wills aren't long enough to cover all of your earthly belongings. That's what a trust is for. Wills also have another weakness. They aren't valid until after you die, so to protect you and make your wishes known while you're still alive, you need durable powers of attorney. Durable powers of attorney are kind of like a will, except it covers any actions you want taken before your death. There's a few situations where DPAs might be used, but one of the most common is if someone suffers a traumatic brain injury or is otherwise unable to express their wishes. If you don't have one of these set up with your intentions clearly stated, then things get very legally messy and gray, and people are often left feeling slighted or betrayed by whoever ends up making the hard decisions for you. And everyone will always question whether or not the action taken was what you would have wanted. Not having durable powers of attorney set up leaves you extremely vulnerable to someone who knows how to manipulate the legal system for their own nefarious gain. This is meant to protect you from that. And speaking of protection, that's what a trust does, but for your stuff. A trust is probably the most special of the three parts of an estate plan, because in the eyes of the law, the trust is seen as a separate legal entity altogether, like it's a separate person. The way you use a trust is you take your stuff out of your name and put it under the protection of the trust. The trust has three different parties listed under it: the trustor, the trustee, and the beneficiaries. The trustor is the person giving their stuff to the trust. The trustee is the person who acts on behalf of the trust and carries out any actions stated within it. And the beneficiaries are the people who will ultimately benefit from the formation of the trust. They're the people who will assume ownership of the property in the trust. When people hear this breakdown, they often start to get nervous, thinking that a trust is some fancy legal way to steal your stuff out from under you by taking it out of your name and putting it into a big thing you don't control. But actually, a trust does the exact opposite. A trust is a way to make sure nobody can steal your stuff in a fancy legal way. And although it technically takes your stuff out of your name, you still control it. While you're alive, you are the trustor, trustee, and the beneficiary. It's still your stuff, and you still get to do whatever you want with it. But then, when you die, the trustee becomes whoever you chose to be your trustee, like one of your kids or a trusted family friend. And the beneficiaries become whoever you chose to be the beneficiaries of your trust. Your kids, grandkids, a religious organization, a charity, whoever. The reason you want a trust is because when a person dies, the sum value of all their property is added up, and if it's over a certain threshold, the government takes your stuff to probate court, and the court decides how much they get to take. This is an extremely long and painful process that takes 1.5 years at the minimum, and ends with your loved ones needing to give up a huge percentage of their inheritance. And, oh yeah, all this is happening while they're still mourning the loss of a dear loved one. By taking some of your stuff out of your name and placing it into a trust, when you die, the sum value of your property can be kept below the threshold needed to take you to probate court, saving your family from all that grief, because your stuff is now in the trust, and because the trust never dies, it never goes to probate court. With an estate plan from H&K Inc., you get the will, the durable powers of attorney, and the trust. And we'll see to it that it's properly implemented so your wishes are clearly stated and respected.